Hello students and welcome to the lecture. So students, as we know that we are covering the union and its territories, and basically these are the contents which we have scheduled for the discussion under this particular series. Alright, like starting with the introduction, thereafter union of states, thereafter parliament's power, thereafter exchange of territories, thereafter evolution of states and the union territories. Okay, so these are the topics which we have scheduled for the discussion under that particular series. So far, basically we have done with the introduction part and we have checked the union of state. And basically what we have started for the discussion, we had started parliament's power for the discussion. And the topics we are left with is the, you could say the exchange of territories and the evolution of states and the union territories. Okay, so that is the picture we have created so far. So let's start from where we had left in the previous lecture. Okay, so in the previous lecture, we had started a discussion over parliament's power to reorganize the state. Alright, we have seen these areas. We have seen that whenever this is a matter of states, like you could say, whenever the states are to be altered or the state boundaries are to be altered and the modified, then basically presidents prior permission is required. All right, and basically whenever there is a matter of UTs or the union territories, all right, so in this regard the central government, not the central government, basically the parliament, the parliament could take action on its own. All right, so that is the scenario which we had seen in the previous lecture. Now we will continue from here. All right, so basically as we know that the parliament is nothing have to do with the president and the state legislature constitutions and all whenever this is a matter of union territory. So basically it is thus clear that the constitution authorizes the parliament to form new states or alter the areas, boundaries, or name of the existing states without their consent. All right, because as we had seen that the president prior recommendation is necessary, and before giving this recommendation, the president may refer the same matter to the state legislature. All right, and the state legislature is required to review the bill, to look at the bill, and then provides the concerns and the considerations to the parliament and the president. But we have also seen that neither the parliament nor the president is bounded or required to, you can say, pay attention to the concerns launched by the state legislature. All right, so that's why the constitution, as per the article 3, authorizes the parliament to form new states or alter the boundaries, areas, or name of the existing states without their consent. Why? Because state legislature consideration is no longer required. Hence, the territorial integrity or continued existence of any state is not guaranteed by the constitution. Okay, remember, territorial integrity means that in future, whenever there will be a need, the parliament could alter the boundaries of the state. So the territorial integrity, even the existence of a state could be revoked So the continued existence of any state is not guaranteed by the Constitution of India. All right. Therefore, India is rightly described as an indestructible union of destructible states. India is famously known as an indestructible union of destructible states. What does it mean? What does it mean? Basically, if we talk about the previous lecture, we had seen that Indian Union is not an agreement. That's the first thing we had seen. Second thing which we had seen there was that no state could leave the nation. All right. No state could leave the nation. That is also what we have seen. All right. So basically, what do you mean here? We mean that basically Indian Union is not a part of any agreement and no state is allowed to leave the India. That is what here. That India is the indestructible union. It means that no state could destroy the union by separating itself. But the same Constitution of India does not guarantee any territorial integrity or continued existence for any particular state. That's why at any time the center or the parliament could destroy the state's boundary by enlarging or diminishing it, even could revoke the existence of any state and the name of the state could be changed easily. All right. The union government can destroy the state, whereas the state government cannot destroy the union, as we had discussed. In USA, on the other hand, the territorial integrity or continued existence of a state is guaranteed by the constitution. So remember, there are two type of constitutions basically we are talking about. All right. Indian constitution, American constitution. Okay. Two types of constitution we have. Indian constitution, not guaranteed. Not guaranteed. But American constitution, guaranteed. All right. So that is the difference between the two. Okay. The American federal government cannot form new states or alter the borders of existing states without the consent of the state concerned. Like in India, we know by power of Article 2 and Article 3, the central government or the federal government is having the right to enlarge or decrease the area of any particular state, to revoke the existence and even change the name. But when we talk about the USA or the United States, that particular thing is not available with them. It means that they could not alter the borders of existing states without the consent of the state concerned. All right. That is why the US is described as an indestructible union of indestructible states. Described as an indestructible union of indestructible states. All right. So remember, whenever this is like about this, an indestructible union of destructible state. So always remember that we are talking about the India. But whenever it's about an indestructible union of indestructible state, so remember that basically we're talking about USA or America. Got it? Moreover, the Constitution, Article 4 itself declares that laws made for the admission or establishment of a new state under Article 2 and the formation of new state and alteration of areas, boundaries, or name of existing states under Article 3 are not to be considered as amendments of the Constitution under Article 368. All right. So basically, what we could see that there are four articles in this. Article 1, Article 2, Article 3, Article 4. All right. So basically, Article 1 having the mention of territorial extent of union, not union, basically states and UTs. All right. Territorial extent of states and union territories. All right. Thereafter, whenever we talk about Article 2, Article 2 basically talks about the admission or establishment of new state. All right. Thereafter, whenever you talk about Article 3, alteration, establishment, or admission of any state. All right. And the Article 4 basically states about no amendment is required for provisions of Article 2 and Article 3. All right. So basically, here you could see that these are the totally four articles. First article contains the territorial extents of the state and the union territories. Second articles talk about the admission or the establishment of new state. Third article talk about the alteration, establishment, or the admission of any state. Fourth article talk about no amendment is required for the provision of Article 2 and Article 3. So here you could see the clear picture. Got it? So why it is said that no amendment is required for the provisions of Article 2 and the Article 3? Why? Because if we look at Article 1, so Article 1 is in the Constitution, which carries the territorial extent of states and the union territories. All right. So it is already mentioned in the constitution. And what we know that whenever there is to be any change make in the constitution, all right, so there is always a need for one thing. What is that? There is always a need for the amendment in the constitution. Amendment in the constitution. All right. So basically, if we look through this picture, so what we are getting here, Article 1 is in the constitution, and because we are changing, altering the boundaries of the state, we are admitting or establishing new state, we are changing the name of the state. So basically, we are making the changes in the amendment of the constitution. All right. And the amendment of the constitution is required to be passed by two types of majorities: simple and the special. All right. So what is the difference between the two? Like whenever we talk about the simple majority, then remember only more than 50% is required. Okay. Only more than 50% is required. But when we talk about the special majority, then 2 by third sitting majority and more than 50% is required. All right. So that is the scenario. So it means that basically, if the change is to be made, amendment is to be made, and the amendment is required to be passed by either by the simple majority or in the or by the special majority. But in case of this Article 2 and Article 3, basically no amendment is required for the provision. That gives the liberty on the parliament that such laws can be passed by a simple majority and by the special majority, or so not special majority, but the simple majority and by the ordinary legislative process. All right. There is no requirement for 2 by third sitting capacity and the 50% capacity. Thus, the power of parliament to diminish the areas of state under Article 3 includes also the power to cede Indian territory to a foreign territory. So that is a question. Like, suppose if we talk about this, then suppose there are three states. Just take an example. There are three states. All right. Point X, point Y, Z, or W. For example, A, B, C. So this YX is a boundary between A and B. This ZW is a boundary between B and C. All right. But suppose what happened that the boundaries has been altered by the parliament. All right. Okay, so that is a that is Z and W. All right, that is Y, that is X. B and C. What happened? That the parliament decided that the boundaries of B must be increased, and now the new boundary is Z1 and W2. But what happened? That state B has gained the area, but state C has lost the area. All right. So it means the portion of C has been ceded it to state B. All right. That's the question. Like suppose this is about the internal methods. But if we take the third scenario, for example, this is our country and having three states A, B, and C. And here is another foreign country X, Y, and Z. All right. So suppose the Parliament of India having the power to alter the boundaries of the country. That's what new. So if government wants to transfer some portion of a country to any other foreign country, will this be a part of that the parliament's power to diminish the area of a state under Article 3? Does this article also includes the power to cede Indian territory to a foreign country? So that is the question which I have told you through the example. This question came up for the examination before the Supreme Court in a reference made by the President in 1960. Why Supreme Court? Because remember that, as I have told you many times, in India, things are being running by the Constitution. All right, being running by the Constitution, and basically the Supreme Court is considered as the guardian of the Constitution. Why? Because the Supreme Court having the power of judicial review. So whatever the government or the concerned party did, the Supreme Court could review the matter on the basis of constitutional provisions. All right. So basically, that was a time period in the year of 1960. Which is the year? The year is 1960. All right. When the question regarding, you can say, examination regarding this question has been presented before the Supreme Court by the President. Okay. The decision of the central government to cede part of territory which was known as the Berubari Union, which lied in the West Bengal, and West Bengal is a part of Indian territory, to the Pakistan, led to the political agitation and controversy, and thereby necessitated the presidential reference. So what happened? That was a time period in the year of 1960 when the central government of that time, they decided that they would give the territory of Berubari Union, which used to be lie in the West Bengal, to the state of Pakistan. And this decision basically led to the political agitation. and a lot of controversy and makes it necessitated that the presidential reference is required. Okay, the court held that the power of parliament to diminish the area of state under Article 3 does not cover cessation of Indian territory to a foreign country. So what happened? That during this time, the parliament did whatever they did. The Supreme Court told this or held this that the parliamentary power to diminish the area of a state, which is you could say powered and granted by the Article 3. It does not cover cessation of Indian territory to a foreign country. It means that the parliament is not allowed to cede any territory of India to any foreign country by using the powers which has been granted by the Article 3. Got it? So remember what happened in the Berubari case. Hence, the Indian territory can be ceded to the foreign state only by amending the constitution under Article 368. Alright, which means that the provisions of Article 4, which states that the you can say cessation of the territory of the country, not cessation, basically the alteration of boundaries, diminishing of the boundaries of the states. These provisions are not a part of the constitution. All right, or you can say not require. So basically, the provisions of Article 4, which states that basically the power of the parliament to diminish the area of the state, alter the boundaries of the state, rename the state, all these powers which has been granted by the power of Article 4. All right, sorry, Article 2 and 3. And Article 4 says that these powers are not subjected to the Article 368, which means that to exercise this power, the amendment in constitution is necessary. All right, so that provision is not applicable whenever the cessation is about to cessate the territory to any foreign state. Okay, so for this, if the government wants to cede the territory of India to any foreign state, then basically they are required to make the amendment under Article 368. And that's required the special majority. Consequently, the Ninth Constitutional Amendment Act, which was passed in the year of 1960, that was enacted to transfer the said territory, which was the Berubari Union to the Pakistan. On the other hand, the Supreme Court in the year of 1969, 9 years after the incident, ruled that settlement of a boundary dispute between India and another country does not require a constitutional amendment. Okay, so in the 1960s judgment, they said the amendment is necessary, but when the judgment, another judgment come in the year of 1969, okay, the you can say the Supreme Court said that it does not require a constitutional amendment. Can be done by the executive action as it does not involve cessation of Indian territory to a foreign country, but only the matter of settlement of boundary dispute, not the cessation. Whenever the cessation is there, so basically the you can say amendment is required under Article 368. But when it is just about settling of the boundary dispute between the India and other state, so no constitutional amendment is required and the executive action could be taken. So students, basically in this lecture we have finished till here. In the next lecture we will start from here. Till then, just revise all the facts and figures which we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and say thank you.